Hi, hello, how are you all? Welcome to my channel Law Made Simple with me Vidya Reddy. Today let us learn the very important topic in company law, that is doctrine of lifting the corporate veil. As we all know that company enjoys a separate position from that of the position of the board of directors or its owners. There is some human agency involved so that the company is able to perform its functions. When this human agency is working in the name of the company for achieving the goals approved by law, the social order is not disturbed. But when the directors or whosoever is in charge of the company start committing frauds or illegal activities or even activities outside the purview of its objectives or articles of the company, then comes the lifting of the corporative wheel is initiated. This doctrine is lifted, this ring of wheel is lifted under two conditions: by statutory provisions and by using judicial interpretations. Under statutory provisions, the Company Act 1956 had laid down certain provisions under which the directors or members of the company will be held personally liable. First condition is prediction in the membership below the statutory minimum. If the number of members of a company is reduced below the statutory minimum, that is below 7 in the case of public company and below 2 in the case of private company, and the company continues to carry on the business for more than 6 months, and after the membership so reduced also, every continuing member who is away, who knows this fact, shall be personally and severally liable for the payment of all the debts contracted during that time. The second condition is when there is a failure to refund application money. In case of application, money is not repaid to those who have not been allotted shares within 130 days of the date of issue of prospectus, then the directors of the company shall be jointly and severally liable to repay that money with the interest at the rate of 6% per annum from the expiry of 130th day. The third provision is when there is a misstatement in the prospectus. In the case of misstatement of the prospectus, every director, promoter, and every person who organizes the issue of such prospectus is liable to compensate to those who subscribe for shares on the faith because of them. Besides, they would be liable for the damages for the deceit under the law of torts. The next condition, to impose the directors with unlimited liability. Ordinarily, the liability of directors is limited. However, there is nothing in this act to prevent their liability from being made unlimited by incorporating such a provision in the memorandum at the original through subsequent alteration by means of a special resolution, only if the company is so authorized by the articles. In those cases, unlimited company liability of directors, they shall be personally liable for the debt of the company. The next condition is to establish a relationship between the holding and the subsidiary company. When one company controls the management of the another, then the former company is called holding company and the latter one is called subsidiary company. Legally, they are considered to be separate entities. But in certain cases, however, subsidiary company may lose its separate identity. They are required to present a joint picture of state of affairs at the end of the year, or what so-called group accounts, to secure better information about the accounts and financial position of the group as a whole for the benefit of shareholders, creditors, and the public in general. The next condition is when there is a fraudulent trading. In the course of winding up of a company, it appears that any business of the company has been carried on with the intent to defraud creditors or any other persons or any fraudulent purpose. The court may direct that those who were knowing parties to such fraudulent trading shall be personally liable for all or any of the debts of the company without any limitation of liability. The device of artificial personality cannot be used to shelter those fraudulent persons. So in all these conditions, the lifting of corporate wheel and looking out who are responsible for defraudulating and who is making the company responsible for all these fraudulent activities will be taken into consideration. The next method of lifting up of the corporate wheel is by judicial interpretation. The courts lift the corporate wheel whenever it is necessary to secure justice or if it is in the public interest. They determine by enemy character of the company. The court may examine the company to ascertain whether it has assumed any enemy character or there exist any interlocking directorates. For this purpose, the membership of the company is scrutinized to ascertain who is in real control of the corporate affairs. To permit alien enemies to trade under corporate clock will be against the public policy. This we can see clearly in the case law of Daimler Company Limited versus Continental Tire and Rubber Company Limited. A German company was incorporated in England for the purpose of selling tires made in Germany by a German company. And majority of the shareholders and directors were Germans resident in Germany. But when the First World War broke out, the company commenced an action to recover its trade debt. But the House of Lords held that the company had become an enemy company as it was controlled by the residents of an enemy country, and the suit was dismissed on the ground that such permission would be against the public policy. Is further protection of revenue. The corporate personality may be ignored or it can be lifted when the company has formed merely for evading the tax liability. This we can clearly see in this case law of Sir Dinshaw Manakji Petit. Dinshaw, he is an SSC, was a millionaire enjoying huge dividends and interest as income. He floated 4 private companies and transferred his interest to them in exchange for shares. The income was received by the companies and thereunder handed out the SSC as a pretended loan. Actually, there were no companies at all. Whatever is created is only on the paper, and as such, there was no companies at all created by this Dinshaw. The House of Lords held that the company is not carrying on any business. It was nothing more than the SSC himself who created ostensibly to reduce the tax liability. So such are those fraudulent cases. And next, coming for the prevention of fraud or improper conduct. So in the case of Guilford Motta versus Horney, here the defendant Horney was a former employee or the managing director of the plaintiff company Guilford Motta. He had contacted with the Guilford Motta company not to solicit the plaintiff's customers. So in contrary to this obligation, he formed a company in his own wife's name carrying this similar business and dealt with plaintiff's customer. When the matter was brought into the court, it was held that the newfound company was a mere clog or a sham for the purpose of enabling Horney to commit a breach for his covenant against solicitation. So people are becoming so fraudulent and committing very improper conducts to their own businesses and making money out of it. In another case, when the company is acting as an agent or trustee of the shareholders. In the case laws of Bharat Steel Tubes Limited versus Industrial Finance Corporation of India, and another case of New Tirupur Area Development Corporation Limited versus State of Tamil Nadu, though these two companies were created as a public-private corporation, the government has paid up share capital of less than 51%. In this Bharat Steel Tubes also, it is less than, the government should be holding more than 51% of the paid up share capital, but it is not there up to that mark. And in the case of New Tirupur Area Development also, the government was just holding 17% of the investment funds. So in this case also, the company has to be re-rectified whether it is acting as an agent or a trustee to the shareholders. Again, in another case, to prevent transactions which are contrary to public policy, when the conduct of the company is in conflict with the public interest or public policies, courts are empowered to lift the veil and personally hold such persons who are liable and who are guilty of these acts. As such, we have come to the end of the session. It's riddle time. Please answer the riddle in the comment section. Please like, share and subscribe. Thank you.